afternoon, everyone, and welcome to today's webinar. Thank you so much for joining us. It's great to see so many of you with us today for the webinar. So as you're already aware, today we're going to be talking about the Good Work Plan. And in particular, I'm going to be focusing on the Fair and Decent Work section. Now, there is so much information to give you about the Good Work Plan. We've split this into 3 webinars, really to make it a bit more bite-sized, manageable chunks to help you understand all the changes that are coming into place. So firstly, to quickly introduce myself to anyone that hasn't watched our webinars before, my name's Hannah and I'm one of the senior HR advisors within the Code Total HR team. So a key part of my day-to-day role is supporting our Total HR members with any practice queries that they have. So it's great to see so many of my Total members joining me today as well. So we're just going to have a quick look over the aims and objectives of today's webinar. So the aim of today's webinar is to increase your understanding of the changes to employment law that the Good Work Plan will introduce, with a particular focus on fair and decent work. So the objectives of today's session are to discuss an overview of employee rights relating to the Good Work Plan, to highlight the risks of failing to follow employment law, and to explore how Code Total HR provides essential policies and template letters to help you comply with your legal obligations. So the learning outcomes from today's session, they will be to improve your understanding of the changes to employment law being brought into effect by the Good Work Plan, to understand statutory employment rights, and to avoid potentially costly mistakes relating to employment law. So in order to achieve these aims, objectives and learning outcomes, in today's session, I'm going to provide you a bit more information about the Taylor Review, what it was, a bit of history and background to it, the main areas of reform under the Good Work Plan, in particular with a focus on the Fair and Decent Work section, the key changes. So these are the right to request a more stable contract, the increase in the break in continuous service, some of the changes for agency workers, and the change for information and consultation arrangements. Now, towards the end of the presentation, I'll also talk about how to minimise the risks for your practice, and at the very end there will be a question and answer session. So firstly then, really a bit of background regarding the Good Work Plan. So it all derived from the Taylor Review. So Matthew Taylor completed his review of modern working practices, and this was really the first of its kind. It's very unique, and it was really introduced because there's been so many changes to how workplaces operate, and employment legislation hasn't kept up to date with that. So things like flexible working, mental health, corporate social responsibility, technology, and I'm sure you've all heard about the changes for self-employed workers and employment status. So the big sort of cases like Uber, Pimlico Plumbers, I'm sure you've all heard about them. So they all contributed to the Good Work Plan really being introduced. And a lot of this really is based around giving employees and workers a fairer deal, making it fairer for them. So as we go through our series of webinars, you'll sort of realise a lot of these changes are more based around the employee and improving things for them. And particularly in our industry, there is a lot of female workers. So it is potentially going to have quite a knock-on impact. Again, a lot of the changes around 0 hours and casual workers. And within the dental industry, we do have a lot of employees and workers who are 0 and casual hours. And again, a lot of them are female, perhaps for sort of caring responsibilities, maybe for young children, elderly relatives. So it is going to have a real knock-on impact. Now, you notice the very last bullet point on my slide, I am only going to briefly mention Brexit, but Brexit has had a real knock-on impact to the Good Work Plan. So Matthew Taylor released his review of modern working practices in July 2017. The Good Work Plan was then released by the government in December 2018. So the Good Work Plan detailed the changes that the government are going to make on the back of that review of modern working practices. And as you already realised, a lot of the changes are only going to be implemented over the next few weeks. So it has really delayed the Good Work Plan, and also Brexit sort of overshadowed it as well. So there hasn't been as much perhaps in the news and the press as there normally would have been with significant employment law changes because of Brexit. So most of the changes for the Good Work Plan are coming into effect April 2020. There are a couple of changes that have already come into place, which I'll talk to you through in a moment. But the Taylor Review consisted of 53 proposals for change to employment legislation. And the government have implemented 51 of those proposals. So I'm sure you've already realised it's going to have a big impact upon employers. Now, we're not going to go through every 51 of those changes because we're going to need more than 3 webinars. We're going to be here for quite some time. So what we've done is we've stripped down the Good Work Plan, pulled out the essential parts that are really going to impact yourselves as practices. So those are the ones we're going to go through and talk through with you. So firstly then, the main areas of reform under the Good Work Plan. So the first main area of reform is fair and decent work. So these are the changes that I'm going to be talking to you today. The second section is clarity for employers and workers. So this covers things like self-employment status, IR35, more changes for agency workers, more changes to contracts. So again, lots of relevant changes, and that's going to be covered in our second webinar on the 20th of February. And the third area of reform under the Good Work Plan is fair enforcement. So this covers some of the changes that have already come into place, and it's mainly around sort of tribunal penalties. And that's going to be covered very briefly today, but mainly it's going to be covered in our third webinar in the series, and that's on the 5th of March. So just quickly having a look at the changes that have already come into place from the Good Work Plan. So one of the first key changes is around pay slips. So from 2019, it's a requirement now to provide pay slips to your 0 hours and casual workers. Now, we know a lot of practices were already doing this, but if you weren't as such, from 2019, it was a requirement to provide that to them. But it's also a requirement now to put on those pay slips the number of hours that are worked for employees and workers whose pay varies depending upon those number of hours. So it's almost, you have to specify how that calculation for their pay is made up. So that needs to be detailed on their pay slip. Now, a couple of other changes that have already come into effect come under the fair enforcement section of the Good Work Plan that I mentioned just a moment ago. And this is around penalties, so penalties at tribunals. So if you're an employer who is regularly attending a tribunal, regularly losing at a tribunal, and also not paying awards to employees and workers within a specified time frame, there's going to be additional penalties for you. And naming and shaming has also been brought into force. So again, for employers who regularly at tribunals, regularly losing or regularly not paying making those payments. So there is a naming and shaming facility. And I'm not going to go into too much detail about that. So a lot more about the specific monetary values, the costs, that will be covered in our third webinar, but just to make you aware of some of the changes that have already come into effect. So one of the first key changes I want to make you aware about with the Good Work Plan is from April 2020, employees and workers will have the right to request a more predictable and stable contract. Now, this comes from recommendation 12 and 13 of the Taylor Review. So under this new right, they will be able to request things like guaranteed hours. So for example, your 0 hours team members, they can request guaranteed hours are written into their contracts. They have a more stable contract. But potentially, if they still want a little bit more flexibility, they could request a minimum number of guaranteed hours. But it also could impact on the days per week, so it could be a request for certainty on the days of work. So although this change in legislation is mainly aimed at your 0 hours and your casual workers, giving them a bit more stability, it could also have a knock-on impact to the rest of your workforce. So what we're currently doing within the CoTotal HR team at the moment is we're developing a policy that will support you as practices, but also help your employees and workers understand how these requests will be dealt with. Now, we are still waiting for the government to confirm a lot of the legislation around this, how it will work. But what we do know at the moment is that employees and workers who have 26 weeks continuous service will be eligible to make a claim for a more stable and predictable contract. They will have that right to put in that request. And as an employer, you will have 12 weeks to make a decision of whether you will be accepting or whether you'll be refusing that request. So it's going to be a very similar format to the flexible working request procedure. And it might be, and this again is something we're waiting for confirmation on, that there are specified reasons that you can refuse a request. But what we do know is that you are going to need good justification to refuse a request, particularly for your 0 hours employees who regularly are working hours and they are requesting them to be written into their contract. If it is that they are genuinely regularly working the same hours and they're requesting that, it is going to be very hard to refuse. Now, this change is going to have a real risk to this. If you're refusing requests, it could have a real sort of knock-on impact from that perspective. So it's really important to try and accept those requests where you can, really. But what I think it also highlights is how important it is to have employees and workers on the right contract in the first place. Are they genuinely 0 hours? So it's really important to make sure you've got that right contract in place. So almost you don't have that need to request a more stable contract because it's already detailed for them. And now on the Code Total HR helpline, one of the most common questions, in fact probably the most common question we receive, is around contracts. So if you're not sure about which contract template to implement, how to word those clauses, please get in contact with us. We can help you with that. Now, another key change to let you know about is the change in the break in continuous service. And this comes under recommendation 9 of the Taylor Review. So currently the break in continuous service is 1 week, and that's going to be increasing to 4 weeks. And again, this is mainly going to affect your 0 hours and your casual workers. Now, really one of the reasons that this was introduced was because quite often employers were exploiting that break in continuous service. So they were breaking a 0 hours casual worker, but also employee service so that they didn't accrue rights like maternity pay, paternity pay, right to claim unfair dismissal, or going forward, the right to request a more stable and predictable contract. So almost perhaps because there were some employers that were exploiting this, that's one of the reasons that it has been increased, really. Again, to make it fairer for employees and workers. Now, this could also have a knock-on impact in other areas. So, for example, in a redundancy situation. So if you make an employee redundant, and then because of the uncertainty within the practice, you might have a resignation. If you then decide to bring back to the practice the employee was made redundant, there might be a right to retain that continuous service. But this is a really complex matter, particularly when you've got redundancy pay involved, tax implications there. So if you are in that situation, with this change in legislation, I'd really recommend you seek some expert advice because it'd be really individual to that particular circumstance as to how best to proceed. But on a bit more positive note from an employer's perspective, it might not necessarily apply in a resignation situation. So if it's quite clear that your employee has resigned, they've handed in their notice in writing, you've accepted that resignation in writing also, you've issued their P45. If they leave the practice, perhaps decide where they go to, their new practice isn't for them and they want to come back to you, you don't necessarily have to accept that and give them back their continuous service. That's really dependent upon your audit trail. So if you have a good audit trail, you could potentially break that continuous service. And the key with that example is it's the employee's decision. And this is going to more affect where you as an employer are terminating that contract. Now, there are lots of changes under the Good Work Plan for agency workers as well, and a lot more of them will be covered in our next webinar, the Clarity for Employers and Workers section. But under the Fair and Decent Work section of the Good Work Plan, recommendation 18 of the Taylor Review does affect agency workers. So currently, agency workers are entitled to receive the same pay as your existing employees after 12 weeks of that assignment, so 12 weeks with your practice. But what they can currently do is opt out to receive guaranteed pay, and that's guaranteed pay between those temporary agency assignments. Now, that opt-out is what you may have heard referred to as Swedish derogation. Now, going forward from April 2020, they won't have the ability to opt out. Now, that may seem a little strange, but what really was established as part of the Taylor Review was that actually agency workers who were opting out were worse off financially, and the agencies themselves were profiting from that. So again, it wasn't fair. So to make it fairer, the government have abolished that. So from April 2020, there won't be the ability to opt out. Although as practices, that's not going to necessarily directly affect you. It will be something that the agencies are required to manage. It may have a knock-on impact to you financially if you have long-term agency workers. And we do know some practices that do regularly use agency workers and have them perhaps for long periods of time. So what we would recommend you do is perhaps get in contact with your agencies, check that they're aware of the Good Work Plan, I'm sure they will be, but also understand how they will be implementing this and how they will be managing and dealing with that within their agency. Now, another key change under the Fair and Decent Work section of the Good Work Plan is changes to information and consultation arrangements. And this comes under recommendation 14 and 15 of the Good Work Plan. So currently, if 10% of your workforce requests to be involved in information and consultation arrangements, you're required to implement them. So to give you an example, this could be things like major workforce changes, so redundancy situations, changes in hours, changes in contract, shift patterns, those types of things. And it's almost a bit like an employee and worker union. So you're required to consult with those employees and workers and really get them on board and get them to agree with those changes. So it could be things as well like implementing new policies and procedures. So maybe a policy on the right to request a more stable contract. But from April 2020, that percentage is reducing, and it'll be 2% of your workforce. So if 2% of your workforce request information and consultation arrangements, as an employer, you're obliged to implement this. Now, we do know some practices that do this already, so it could be something like an employee forum. So it is a really good thing for engagement, so it might be something you want to consider anyway. But what the government have sort of continued is the minimum request threshold. So you do require a minimum of 15 employees requesting information and consultation arrangements, in addition to that 2%, so 15 employees and 2% of your workforce before you're required to implement that. So for our smaller practices that are joining us today, it might not have sort of an impact for you. However, we do have sort of groups of practices that are iComply members. Again, you may be joining us today. It may well impact yourselves with that reduction. So again, one to be aware of. Now, I've just done a quick summary here, really, of the key changes because they are so significant. It's a lot of information to take in. And as part of the Co-Total HR team, we've spent a lot of time sort of researching them, establishing the changes, how this will impact yourselves, so that we can pass that information on to you. So just a quick recap then, the main areas of reform, so that's the Fair and Decent Work section. So that's the key changes that I've gone through today. The second main area of reform is clarity for workers and employers, and that's things like changes to IR35, self-employed status, contracts, agencies. So that's going to be covered in our second webinar. And then the third key area of reform is fair enforcement. So that's your things around tribunals, and that's going to be covered in our third webinar. But under the Fair and Decent Work section, the key changes are the right to request a more stable contract, the increase in the break in continuous service, the changes for agency workers with regards to Swedish derogation no longer being available, and the change in the information consultation arrangements being reduced to 2%. So now I really want to talk around the risks for you as an employer and as a practice if you're not complying with a Good Work Plan. Now, the first one, and almost the most obvious one really, is an employment tribunal. If you're not complying with employment legislation, your employees and your workers could take you to an employment tribunal. And we are anticipating that tribunals are going to come down quite hard on employers who aren't complying with the Good Work Plan, because the government are so passionate about improving rights for employees and for workers. But also potentially there could be a knock-on impact, particularly for our industry, because going back to what I mentioned at the beginning, is that there are a high proportion of female workers. So that could also lead to a sex discrimination claim, particularly in relation to sort of caring for young children, elderly relatives, that side of things. And with your discrimination claims, the payout is unlimited. So there may be a real sort of knock-on impact there. But with any new legislation that is being introduced, quite often the boundaries for that are determined by case law. So that's when an employer goes to tribunal and loses at tribunal, and that will establish almost how these legislations will be implemented and dealt with in practice, really. So almost don't be the first one to go to a tribunal. Don't be that one that sets that legislation and that case law there, really. But also from an internal perspective, there are also a number of risks. So again, if your employees don't feel happy, don't feel you're abiding by legislation, they can submit a grievance. Now, for those practices that have already had grievances, you'll appreciate they can take several months sometimes to resolve that grievance. So it can be really sort of time consuming. And during that period of time of the grievance, morale within the practice can be really low. It's quite an unhappy sometimes environment to work in. And that can sometimes have a knock-on effect to your patient experience and your practice reputation if your employees aren't giving the same level of service that they normally would. But also from a practice reputation point of view, we're hearing from a lot of practices at the moment, recruitment is really difficult out there. The market isn't great at the moment for recruitment. And if you've got a poor reputation in your local area for being a poor employer, you're going to find recruitment even harder. And if your staff aren't happy, they're more likely to leave. So again, that's almost a vicious circle with regards to the recruitment. So really important to make sure you're abiding by the legislation to improve the morale within the practice. But all of the bullet points that I've put on the screen really come down to the very last one, is cost and time. All of the things above will cost you money to resolve and deal with, and it will also take a lot of your time as well to sort out. So as always, for our iComply members and our co-total HR members, we have a number of key policies and templates that you can use. So what I've put on the screen at the moment is a list of our employment contracts and also our guidance documents that refer to those contracts. So we are currently in the process of updating these. We're working with our dental solicitors, Rudlings Wakelam, to get them updated to make sure they're good work plan compliant. So for our iComply members that are joining us today, and again for our Total HR members, keep an eye out on your iComply account. You'll receive sort of the normal dashboard notifications, email notifications to let you know when these have been updated. So keep an eye out for those and almost have a look into whether you need to update them. But also for our Total HR members, as part of your annual audit that you will receive, we'll also support you with updating any contracts that you need to in line with the Good Work Plan. So we've put together some immediate actions that are required really to prepare for the Good Work Plan, which is only really a few weeks away. So the first key action is to review your team members' current terms and conditions. Are they up to date? Do they need to be updated? So have a look out for those new contracts that we are releasing on iComply and see whether perhaps you need to update them in line with the Good Work Plan. So are there changes that you need to make as such? But also review your policies and procedures. Again, are they up to date? Do you need to introduce any new ones? So maybe the right to request a more stable contract. So again, have a look out for that on iComply and being introduced. But also assess your workforce. So have you got a lot of 0 hours, casual workers? Do you regularly use agencies? Are a lot of these changes going to affect you? And then the next bullet point I've put in the slide, training and awareness. That's really aimed at our practice owners that are joining us today. So there's a lot of changes. There's potentially going to be a lot of information for you to take on board and also a lot of actions on the back of this. So we'd really recommend that you delegate to your management team, make them aware of the changes, train them on the changes so that they can support you in implementing anything that you need to be ready for April. And also, if you're not sure, please seek some expert HR advice. It's a really common call we're getting on the helpline at the moment about the Good Work Plan and how that is going to affect practices. So please feel free to give us a call. So one of the reasons that we've really introduced the Total HR service is because as practice owners, practice managers, you're so busy with the day-to-day running of your practice, it's really hard to keep on top of big employment law changes like this. So as part of the Total HR service, what we'll do is we'll support you with the setup of your staff handbook and your contracts for both your employed and self-employed team members within the practice. So again, making sure they're Good Work Plan compliant. We'll also review these on an annual basis, again to check they're up to date with any employment legislation changes. But you'll also receive access to an online web application to help you manage your staff, so things like holiday, sickness, and you can also store documents on them as well. But you'll also receive unlimited access to your designated Code HR advisor, who will be able to help you with things like editing support, so perhaps bespoke letters for your practice. So if you're not one of our Total HR members that have already joined us today, I know there's quite a few of you here today with us, if you are interested, perhaps to arrange a free HR health check or a bespoke quote for your practice, please call the number on the screen, so 01409 254 354, or email info@codeuk.com, or alternatively, if you want to book a demo of the system, you can follow the link that's on the screen now. So I want to make you aware of some upcoming events that we've got. So our next webinars. So part 2 of the Good Work Plan series is based on clarity for employers and workers. So as I mentioned earlier, this is things like changes for self-employed team members, IR35, more contract changes, more changes for agency workers. And that's going to be on the 20th of February with my colleague Sophie Eggleton. And our third webinar in our series for the Good Work Plan is going to be based on fair enforcement, so those changes to tribunals, penalties, naming and shaming. And in addition to the Good Work Plan, there's also lots of other employment law updates that are happening. So things like changes to statutory payments, amongst other things as well. So that's going to be all covered in our third webinar. And that's going to be on the 5th of March with my colleague, one of the other HR advisors, Kelly, within the team as well. We're also going to be in attendance at the Digital Dentistry Show in London. So that's on the 7th and 8th of March. So please come and see us there. And as always, keep an eye on our events page on our website for all the events that we've got coming up throughout the year. Now, I know this is slightly off topic, but the compliance team have asked me to let you know about this because we're getting a lot of calls on the helpline at the moment about the DSP Toolkit. So we do have a document on iComply that you can use to support you with this. So this is the IG Improvement Plan for Data Security and Protection Toolkit, M217A. So if you're one of our iComply members joining us today, please have a look at that document. That will really help support you with completing that DSP toolkit. And as always, if you've missed any of our previous webinars, want to watch any of the ones we've done, we've got lots of different topics on there. Disciplinaries, grievances, capability, loads of different ones. Have a look on our website, so follow the link on screen now, and they'll all be available there for you to watch at your leisure.